Hello viewers, welcome to today's lesson on the criminal justice system in India. Judicial systems are broadly divided into civil, criminal, constitutional and administrative courts. The criminal justice system is one of the oldest justice administrative systems and forms the basis of the judicial system. This lesson will discuss the general principles that are applicable in criminal justice systems as opposed to constitutional, civil and administrative courts. The lesson will also look at the hierarchy of courts in terms of the court which has the competence to examine the matter in the first instance and the right to appeal from the determination of this court. The different courts which have been constituted to look into different matters and the culmination of the judicial process. The law relating to criminal justice system is spread over several statutes, but the important legislations are also known as the criminal major acts, which are the Indian Penal Code 1860, the Criminal Procedure Code 1974 and the Indian Evidence Act 1872. The objectives of this lesson are to learn about the general principles applicable in criminal matters, particularly to learn about the court of first instance and appellate courts, to learn about the different courts which have been established in the judicial system and their powers. To first examine the general principles applicable in criminal justice system in India. The right to a fair trial is an internationally acknowledged and recognized right which is part of the ICCPR, which is the International Covenant on Civil and Political Rights. The right to fair trial includes the right to be tried by a fair and impartial forum, the right to be heard, the right to representation, the right to make the best defense, the right to be presumed innocent, the right against self-incrimination and others. These are inferred from Article 14 of the ICCPR as well as Article 15 of the ICCPR. The Constitution of India guarantees several rights and freedoms to all persons and has specific provisions in relation to persons who have been convicted of offences. Article 20, 21, 22 provide safeguards to persons accused of crime and give effect to some of the important components of the right to fair trial. Article 14 provides for equality before the law and equal protection of law, which includes the right to be treated fairly, non-arbitrarily and without discrimination. Article 20 provides for three protections, which are the right against ex post facto laws, that is, no person shall be convicted unless the act committed was an offence under the law in force at the time of the commission of the offence. This means that there can be no retrospective laws made which make an act an offence after it was committed. The second protection is that no person shall be prosecuted and punished for the same offence more than once. This is also known as the principle of author fui acqui and author fui convi, which is the rule in relation to conviction and acquittal, also known as the double jeopardy rule in the United States. There are some differences between these different doctrines, but the Indian Constitution has specific provisions which give effect to this principle. The third protection is the protection against self-incrimination, which is that no person shall be compelled to be a witness against himself. Article 21, unlike Article 20, does not contain a specific protection, but in fact provides the widest protections by stating categorically that no person shall be deprived of life or personal liberty except according to procedure established by law. In the A.K. Gopalan case, this protection was read narrowly to mean that as long as the law prescribes a procedure, it is a valid procedure. This position, however, came to be overturned in subsequent cases, and in the Menaka Gandhi case, the court held a right to just and fair procedure which is implicit in the Constitution. Article 22 provides for protection against arrest and detention in certain cases. It provides that no person who is arrested shall be detained in custody without being informed of the grounds of the arrest, nor shall be denied the right to consult and be defended by a legal practitioner of his choice. Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours, excluding the time taken for journey, and no person shall be detained beyond the period without the authority of the magistrate. These protections do not apply in case of an enemy alien and a person arrested or detained under any law providing for preventive detention. The right to legal aid has been held to be an important element of fair trial, as when there is no proper representation for the accused, his chances of getting a fair hearing are greatly reduced. Similarly, the right to bail has been held to be fundamental right flowing from the right to life and liberty. Although the right to bail is not specifically mentioned anywhere in the statute, it is inferred from both Article 21 of the Constitution and Section 437 of the Criminal Procedure Code. In Motiram and others versus State of Madhya Pradesh, Justice Krishna Iyer observed that social justice is a signature tune of our Constitution, and the little man in peril of losing his liberty is the consumer of social justice. The grant of bail can be stultified or made impossibly inconvenient and expensive if the court is powerless to dispense with surety, or to receive an Indian bailer across the district borders as good, or the sum is so excessive that to procure a wealthy surety may be both exasperating and expensive. The problem is plainly one of human rights, especially freedom vis-a-vis the lowly, and necessitates the Supreme Court to interdict judicial arbitrariness deprivative of liberty and ensure fair procedure, which has a creative connotation after Menaka Gandhi. In addition to constitutional provisions, the Indian Penal Code has provisions for general exceptions, that is, in cases of persons of unsound mind or a child below the age of 7 known as doli incapax, things done in private defense will not be considered as offences. Similarly, the Criminal Procedure Code has been amended to address the need to secure bail to under trial prisoners. Section 436A has been introduced prescribing a maximum period for which an under trial prisoner can be detained. The section provides that where a person has, during the period of investigation, inquiry or trial under this code, of an offence under any law, not being an offence for which the punishment of death has been specified as one of the punishments under that law, undergoes detention for a period extending up to 1/2 of the maximum period of imprisonment stated for that offence, he shall be released by the court on his personal bond with or without sureties. It further provides that no such person shall in any case be detained during the period of investigation, inquiry or trial for more than the maximum period of imprisonment provided for the said offence under that law. Section 2A of the CRPC defines a bailable offence as follows. Bailable offence means an offence which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force, and non-bailable offence means any other offence. In bailable offences, a police officer may give bail, and in non-bailable offences, the bail may be given by the court. The law of arrest has also undergone many changes. After detailed guidelines on arrest were issued in the D.K. Basu case, Section 50A was added to the Criminal Procedure Code, which provides for obligations of persons who are making an arrest. It provides that every police officer or other person making any arrest under this code shall forthwith give the information regarding such arrest and place where the arrested person is being held to any of his friends, relatives, or such other persons as may be disclosed or nominated by the arrested person for the purpose of giving such information. The police officer shall inform the arrested person of his rights under subsection 1 as soon as he is brought to the police station. An entry of the fact as to who has been informed of the arrest of such person shall be made in a book to be kept in the police station in such form as may be prescribed in this behalf by the state government. It shall be the duty of the magistrate before whom such arrested person is produced to satisfy himself that the requirements of subsection 2 and subsection 3 have been complied with in respect of such arrested persons. To look into the hierarchy of courts, the Criminal Procedure Code sets out the different types of courts and the issues they are competent to deal with. Section 6 of the CRPC sets out that apart from the High Court and any court specially set up under any law, there shall be a Court of Sessions, judicial magistrates of the first class, and in any metropolitan area, metropolitan magistrates, judicial magistrates of the second class, and executive magistrates. The state is divided into sessions division, and each such sessions division is a district, and the district judge is in charge of the criminal justice administration in that area. The Court of Session is presided over by the sessions judge, and there are additional and assistant sessions judges. The other set of courts are the courts of the judicial magistrates, and the state government is free to set up as many courts in each district as the state government in consultation with the High Court may decide. The hierarchy of courts as established by the CRPC is that the Judicial Magistrate Court are the courts of the first instance, and above them are the sessions courts. The High Court and the Supreme Court are both courts of appeal, and in some cases involving the violation of fundamental rights, these courts can invoke their writ jurisdiction, and in case of the High Court, their supervisory jurisdiction. Summary trial. Under section 260 of the CRPC, any chief judicial magistrate, metropolitan magistrate, or a first class magistrate duly empowered by the High Court can try the cases specifically mentioned in the section, not being cases punishable with death, life, or imprisonment above 2 years, in a summary manner. The procedure to be followed is the procedure in a summons trial, and the imprisonment cannot exceed 3 months. Special courts have been constituted under the Prevention of Corruption Act 1988, Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989, Protection of Children from Sexual Offences Act 2012 known as the POCSO, and the National Investigation Agency NIA Act 2008. The Magistrate Court also has an interesting power, which is the power to grant maintenance to wives, children, and parents. This is not a criminal jurisdiction, but a social welfare measure. It is important to note that the law of the land considers the abandonment of dependents as an act that can be remedied by resort to a criminal court. Section 125 CRPC provides that if any person having sufficient means neglects or refuses to maintain his wife who is unable to maintain herself, his children, legitimate or illegitimate, who are unable to maintain themselves, or his parents who are unable to maintain themselves, order that he pay them maintenance. These proceedings are summary proceedings which do not require any elaborate process, and the amount that is paid is also distinct from the alimony or other amounts that the wife may claim under any other law. Jurisdiction of courts. The court at the lowest level is called judicial magistrate of the second class. This court is competent to try the case if the offence is punishable with imprisonment for a term not exceeding 1 year, or with fine not exceeding 5,000 rupees, or with both. Sections 28 to 29 of the CRPC set out the sentences which the court may pass. While the High Court may pass any sentence, the Sessions Judge may pass any order authorized by law, including a sentence of death, but the sentence of death is subject to confirmation by the High Court. An Assistant Sessions Judge may pass any sentence other than a sentence of death. The court of a Chief Judicial Magistrate may pass any sentence authorized by law except a sentence of death or imprisonment for life or imprisonment for a term exceeding 7 years. The CRPC categorizes offences into cognizable and non-cognizable offences. Section 2C CRPC defines a cognizable offence as an offence for which, and a cognizable case as a case in which the police officer may, in accordance with the first schedule or under any law for the time being in force, arrest without a warrant. There is also a distinction that is made between compoundable and non-compoundable offences, that is, offences which can be compromised or settled without a trial and those which cannot be so settled. Section 2X of the CRPC defines a warrant case as a case relating to an offence punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. Section 190 of the CRPC provides for two types of procedure for trial of cases by a magistrate: those instituted upon a police report and those instituted other than on a police report, that is, upon complaint. Stages of a criminal trial. A criminal trial is set in motion by the filing of a FIR, or a first information report. This is known as a pre-trial stage, and the police carry on their investigation. A criminal case reaches a court only after the investigation is complete and a charge sheet is filed. Only after a charge sheet is filed is the person against whom the case is filed is called an accused. Until such time, he is only a suspect, and the law presumes that a person is innocent unless he is proved guilty. In a landmark decision of the Supreme Court in Nandini Satpathy, the court held that a person accused of crime has a right to remain silent. The court held that women have the right to be questioned at their homes in the presence of male relatives, have the right to be brought to the police station only after a formal arrest, and have the right to be searched only by other women. Upon completion of the investigation and on consideration of the material before the court, the magistrate is of the opinion that there is ground to presume that the accused has committed any offence. Charges are framed and the trial commences. The magistrate may convict the accused in case he pleads guilty, and in case he pleads not guilty or refuses to plead, a date is fixed for the examination of witnesses. The prosecution shall lead the evidence and has the burden of proof to establish a case against the accused. After the completion of evidence of the prosecution, the accused will lead the defense. The magistrate may convict or acquit an accused on the basis of the evidence led. In conclusion, we have examined the rudiments of the criminal justice system in India. We have examined some of the basic and general principles of the system, the hierarchy of criminal courts in India, their jurisdiction, and the procedure that is followed in the trial of criminal cases. I hope you have enjoyed this lesson. We will meet again for the next lesson.